Another ICC accredited lawyer said, walang pakialam na ang ICC sa mga issues natin dito sa Pilipinas. They're not even following that. Nandun na si Duterte, didinggin nila yan.
Yes, that is expressed in the Latin maxim, which is a doctrine of international law, male captus bene detentus. No? Wrongfully arrested, but the detention is good.
All right, we're now joined by former Supreme Court Associate Justice Antonio Carpio. Good morning to you, Justice.
Good morning, Karen. Good morning to our viewers.
All right, you've heard Vice President Sara Duterte. I want to ask you first at this point, do you think that former President Duterte can still come home?
Well, I agree with VP Sara that it's unlikely that former President Duterte can come home and until the case is over, and that is only if he is acquitted. If he's not acquitted, then he cannot come home anymore.
Now, let's talk about that. There's been a case at the ICC. I know that his team wants, do you call it an interim release, right? And it's happened before. The ICC has granted an interim release to one of the leaders, if I'm not mistaken, Kenya. So it has happened. Why don't you think will the ICC give it to Duterte?
Well, I think that case involved an accused who voluntarily surrendered. So having voluntarily surrendered, he is not a flight risk. But all those who were involuntarily brought against their will to the ICC were never given any interim relief. No, they were not allowed bail. So I think that will apply to former President Duterte.
Now, the shortest time of the hearing, you have 2 years, and that was an acquittal, the longest being 8 to 12 years. But the other leaders had more charges. They had roughly 7 or 8 charges. Duterte has actually 1 charge. What are you seeing, Justice Carpio, in terms of the timeline?
I think it will be shorter for former President Duterte because he has only 1 charge, no? And there are many witnesses already, and he has admissions. And these admissions are admissible. I mean, they will be considered by the court. He admitted that he had a death squad, he ordered the killing, and he accepted full legal and moral responsibility. So he's bound by that.
So in other words, how the best evidence, and some lawyers have said that, is what came out of his own mouth.
Yes, that's correct. And all of these are captured on video, and they will all be submitted to the court, and the prosecution will use this in the trial.
Okay, now let's talk about, because this is a first, right? It sets a precedent. And I'm sure you watched the Senate hearing that was chaired by Senator Amy Marcos, the Committee on Foreign Affairs. And let's talk about that. There are 2 ways. If there's an arrest warrant, it's via extradition or surrender. Pinag-usapan yun doon. Were Duterte's rights violated? Article 59 of the ICC, right, states that he should first have been brought to a custodial state, a justice system or a court of the custodial state, which means the Philippines. In this case, the warrant was served. He did not have a chance to question the warrant, bring it to a court, and immediately he was shipped off to The Hague. Let's talk about that, Justice Carpio, because they keep quoting Republic Act 9581, if I'm correct.
51.
89, oo. Wala bang nilabag sa proseso ni Rodrigo Duterte?
Well, the DOJ is invoking Republic Act 9851, Section 17, which gives the relevant Philippine authorities the option to prosecute the accused here in the Philippines or to surrender the accused to an appropriate international tribunal. And that's what they did. They surrendered former President Duterte. Now, in Section 17, there is no requirement that he should be first there must first be a petition before the RTC for a warrant of arrest. That applies only to extradition cases. If you look at Section 17, it separates surrender to an appropriate international body and an extradition case to another state. Because if you surrender to another state, an accused, that is called that is under the extradition treaties or convention. And under Philippine law, that we have an extradition law, you have to go to the RTC to get a warrant of arrest. But in the case of surrender to the International Tribunal, the extradition law doesn't apply because the extradition law applies only to from state to state, between two states, and the ICC is not a state. If you look at Section 17, there is a comma after International Tribunal. It says the Philippine relevant authorities can surrender the accused to the appropriate international tribunal, if any, comma, or another state pursuant to the extradition laws or conventions. So the extradition laws or conventions applies only to another state.
Section 17, yan ng Republic Act
9851.
9851. Okay. Kasi
there is no requirement of going to the RTC to get a warrant of arrest under Sections 17. So it's an open case.
Yeah.
If the issue now is before the court, and the issue there, if you apply Section 17, you voluntarily surrender the accused to an international tribunal, do you have to go to a local court to get a warrant of arrest? Because it's not in the Republic Act 9851. The local arrest applies only to extradition to another state. So that is an open question. I think it could go either way, but the administration has reason to believe that they did the proper thing, because Republic Act 9851 does not require a warrant of arrest from a local court. That is expressly required only because it says or to another state pursuant to the extradition treaties or conventions.
And I think this may not matter right now because former President Duterte is in The Hague already.
Yes.
But with the others, you have, I believe, 5 others who are being investigated by the ICC. But let's talk a bit. Do you remember, I don't know if our viewers remember, the case of Mark Jimenez. Mark Jimenez, right, who was convicted in the US for, I believe, illegal campaign donations, and he was actually extradited, but somehow he was extradited to the US. But some have said Mark Jimenez he was able to exercise his rights as a Filipino citizen. When the US was extraditing him, there was an arrest warrant. He was able to bring it to the Supreme Court. Were you in the Supreme Court then, Justice?
I was not yet in the court at the time.
Okay. You were not yet.
That one is pursuant to an extradition treaty. And all extradition treaties are governed by the Philippine extradition law, which requires a petition with the RTC to be filed by the DOJ. But this is a surrender to an international body. You do not enter into an extradition with an international body. An extradition is between one state and another state. That's why in Section 17, it's separate.
Yeah.
Surrender to an international tribunal is separate from surrender to a state. It's you can see the or there.
Okay. So hypothetically, if let's say there was a Filipino, let's say a serial killer, and ang FBI wanted siya. Let's not talk about extradition. I know that we have an extradition treaty with the US, but hypothetically, let's say the FBI wanted him or another foreign police body. Under that law, is the Philippine government allowed to, let's say, the warrant comes, arrest the Filipino citizen and outright surrender him to a foreign body abroad, whether it's the FBI or other foreign police agencies?
Well,
we're allowed to do that?
Yeah. If you surrender it to a treaty country, because we have a extradition treaty, you have to follow the extradition law. That's it. You just have to file a petition with the RTC, and we've followed that all the time. If there is an extradition treaty with another country, the DOJ always files the petition for a warrant of arrest.
Oo.
But for
Pero,
international tribunal, we don't have an extradition treaty with an international tribunal, and that is the big question. It's an open question.
Yeah.
There is no prior decision. There's no precedent here, so it could go either way. The Supreme Court could decide this either way.
okay. So another question is, if the ICC can issue arrest warrants to all leaders who they believe have committed crimes against humanity, issue a warrant, and the country can cooperate, then why do you have to be a member state? What is the point of being a member state when they will still have jurisdiction with the leader of that any country, even if you are not a member state? So
Yeah,
technically, what's the point of
Because
being
it's an option. Like when we enacted Republic Act 9851, we did not want to be a party to the Rome Statute. We didn't want to be under ICC, because under ICC you are obliged to surrender. Obliged. We wanted to have the option to prosecute the accused here or to surrender. That was the law when we passed the 1951, until we became a member later on. We became a member because of the Maguindanao massacre. There was a pressure to be party to the Rome Statute. But because a state wants to retain the option. But if you are a member, you are obliged to comply with the warrant of arrest.
Oh, okay. Now, a video was shown in the Senate. This was of the late Senator Miriam Defensor Santiago. So in 2011, she was elected as a judge of the ICC. But of course, I believe she didn't take that, if I remember correctly. But she actually spoke in the Senate when the Philippines became a member. And in her speech, she said that when an arrest warrant is issued, the courts, it's in the condition that the courts in the Philippines are not working, that the judicial system has broken down. What are your thoughts on that?
Well, that's still in the law now. If you're a member of ICC, ICC can come in only if the local authorities are unable or unwilling to prosecute and to investigate and prosecute. Now, during the entire time that Duterte was the president, there was not a single investigation against him.
Yeah.
That was the DOJ was supposed to do that, but it never. The DOJ never conducted a preliminary investigation against Duterte. That's the duty of DOJ. They never filed a criminal information against
but
Duterte.
couldn't it have been done now? I mean, it's a whole new administration.
It could be done now.
Couldn't they have done it now?
It could be done now, but under our law, it says there under 9851, if there is a tribunal abroad, international tribunal that has already investigated or prosecuted, we have the option to just surrender him. And that's why we surrendered him, because it becomes now an option. Because they have already done the work. There's no reason to repeat what they've done.
So I think at the end, the reason that there's a lot of questions surrounding this is, while the intention may be good and that's an option, how do we prevent as Filipino citizens that the law is not used for political self-serving purposes? How do we protect Filipinos also not to be victimized that the law is used because of who sits in power, it serves them, right? So I think overall in the future, moving forward, you may have administrations that can use the law, the ICC, for their own purposes. How do we prevent that and protect each Filipino's right?
Well, for assuming we are a member of ICC still, we cannot just surrender unless there is a warrant of arrest. The ICC has to issue a warrant of arrest, and it takes time. They go through, they scrutinize everything. It takes longer to get a warrant of arrest from ICC than from a local court. So there is that fear that we could just turn over somebody to the ICC. I think that's far-fetched because the ICC is more strict in issuing warrants of arrest.
So I want to ask you, let's say Senator Bato de la Rosa, a warrant of arrest is issued against him. Being a former Supreme Court justice, a senior at that, if the senator, this is discussed now, you have a former Senator Ping Lacson, right? A warrant was issued against him. He went into hiding 14 months and he exhausted all means legally until the Supreme Court invalidated the warrant. Hinintay niya yun, so nagtago siya. Ang tanong ko, so si Senator Bato de la Rosa, for example, pag nagkaroon ng warrant against him, can he do that, what Senator Ping Lacson did?
Well, that's his choice if he wants to hide, no? But I think there's a pending case in the Supreme Court now on that issue, so that will guide us whether, despite the provision of Section 17 of Republic Act 9851, that the relevant authorities have the option to surrender the accused to an international tribunal, whether that still requires a warrant of arrest because the law is silent. That will be resolved soon. So that will clarify everything.
On that note, is there anything you want to add, Associate Justice Antonio Carpio? Because clearly, even for academic discussions, this is what's talked about in law school today. This is what's discussed in all classrooms in law school.
Well, there are two levels. You have the international law level and the national law level. As far as the ICC is concerned, the surrender of Duterte is final. And they will not inquire how he was brought before the tribunal, whether there was an irregularity or illegality. They are not part of that, so they will not be responsible for that. Once you are with the tribunal, then they will proceed to conduct the trial. And that's exactly what's happening. But for us here, we're still left with this issue whether Republic Act 9851 stands on itself. There is no need of a warrant of arrest from a local court, or there is. So we're waiting for that decision of the Supreme Court, and I believe it can go either way.
Yeah, actually, you reiterate what another ICC accredited lawyer said. Walang pakialam na ang ICC sa mga issues natin dito sa Pilipinas. They're not even following that. Nandun na si Duterte, didinggin nila yan.
Yes, that is expressed in the Latin maxim, which is a doctrine of international law, male captus bene detentus. No? Wrongfully arrested, but the detention is good.
Is all right. Okay, thank you so much for joining us today. Former associate.
Thank you also, Karen. Thank you to our viewers.
Thank you. It's always such a learning experience with you. Thank you. Thank you.
Okay, bye.